Well, it's just turned 2 o'clock this afternoon in London, and I want to extend a warm global welcome to all of you who are gradually coming into this meeting, wherever you may be. For those who don't know me, my name is Mark Hill. I am the Vice President of ICLARS, the International Consortium for Law and Religion Studies, and this is the second in their 2025 series of webinars. It's being generously hosted by the Ecclesiastical Law Society, and I want to express my personal gratitude and that of ICLARS to the Reverend Russell Dewhurst, who has been responsible for the organisation of today's event, and to the Reverend Dan Grayson, who is dealing with the technical side of today's Zoom. At ICLARS, we cover a very broad range of subjects where law and religion coincide, and the webinar series reflects the eclectic and mixed nature of our overall themes. Today's is a rather specific and particular topic, that of Anglican Canon Law, and I am pleased to welcome three distinguished Anglican canonists who in a moment will introduce themselves. Our intention is to follow a broad agenda which we have agreed between ourselves in the form of a loose conversation rather than have a series of individual presentations. And my hope and expectation is time will be available at the conclusion of our conversation to bring in comments and questions from you wherever you happen to be. So if you feel the urge to make a comment or make a suggestion, please use the electronic hand feature, which will lead to the little yellow hand appearing on the screen. And I will then try to direct the Q&A at the end, and Dan will deal with the technical side, unmuting you as and when required. As many of you know, I practice ecclesiastical law in London. I have written on the subject, and I have the privilege of being diocesan chancellor or judge of three Anglican dioceses, Chichester, Leeds, and Europe. And that explains my interest in the subject. I'm now going to go around each of our three speakers so they can introduce themselves. Firstly, to the beautiful country of Lesotho in southern Africa, and to Bishop Vicentia. Can you say a few brief words, Bishop, about yourself?
Thank you, Mark. My name is Vicentia Khabe. I'm the Bishop of the Diocese of Lesotho in Southern Africa, the province of Southern Africa. I am, yes, a bishop. I was a former dean and rector of a theological college in Southern Africa for 7 years, and a student of Norman on canon law.
Well, Norman, the natural segue is to you. You very kindly agreed at short notice to come today and to step into the shoes of Russell Dewhurst, and thank you so much for doing that.
Okay, I'm Norman Doe. I teach law at Cardiff University in Wales. I am the Chancellor of the Diocese of Bangor in the Church in Wales, and I have a keen interest in Anglican Canon Law.
Thank you very much. And our final participant from Canada is Alan Perry. Alan, a word of introduction, please.
Thank you, Mark. I'm Alan Perry. I'm the General Secretary of the Anglican Church of Canada. Some of you might say Provincial Secretary, and have a very great interest in canon law. I participated in the Principles Project, which Bishop Vicentia will be speaking about later, and also studied under Professor Doe. So very glad to be here.
Thank you very much. I too should declare the same interest, having also studied at the feet of Norman Doe many years ago. Norman, can I come first to you to begin our conversation? And can I ask you the complex question, which I hope you will simplify in your answer, of describing the nature of Anglicanism?
Well, Anglicanism is one of the 22 families of churches or traditions recognized as such by the World Council of Churches. Anglicans are configured in their institutional churches in 42 provinces around the world, covering about 160 countries, and there are 85 million Anglicans roughly, and Anglicans are associated together under what is classically known as the bonds of affection, that is loyalty to Scripture, the two dominical sacraments, threefold ministry of bishops, priests, and deacons, and the spirit of the Book of Common Prayer, 1662. And institutionally, they are gathered together in churches which form part of the Anglican Communion, which is understood in the principles, more of which later, as a fellowship of churches which assert, each one in its legal texts and doctrinal texts, each church asserts its membership of the Church Universal, and they're configured, constituted on a national basis, a regional basis, a provincial basis, on the basis of various juridical categories of institutional church. And the fellowship of the communion is rooted in this idea of ecclesial communion, which is fundamentally a theological category, but of course has juridical manifestations. And this notion of ecclesial communion, as expressed in the laws of churches, is one in which a church will assert its membership of the Anglican Communion, or its communion with the See of Canterbury, or its communion with the Church of England, or its communion with all Anglican churches, or it's, as in the case of Nigeria, its historic relationship with the faith as received in Anglicanism. So I think there's some top points about the nature of Anglicanism from a somewhat juridical perspective.
Top points, excellently delivered, talking about things that are held in common. But I think one of the concepts one often speaks about with Anglicanism is the autonomy of each of the component provinces or the component churches. Alan, can I ask you to talk a little bit about this nature of autonomy and sort of juridical independence within a common structure?
The question of autonomy around the communion is partially a question of just the historical development of the churches around the world. As people from the Church of England began to move into different parts of the world and sort of took the church with them, eventually those other jurisdictions began to kind of split off from English authority, even though they stayed, with one exception, in the British Empire. And so they began to develop their own need for a kind of a local expression of what the church was and could be. At first, this was somewhat controversial, but eventually it came to be the norm. So really, you need to look pretty closely at the particularly at the 19th century, with the disestablishment of the Church of Ireland, for example, early 20th century disestablishment of the Church in Wales. And of course, the Episcopal Church of Scotland is a whole different kettle of fish as well. So what you have now is, as Norman said, 42 provinces in 160 countries, each with their own context, geographical context, political context, legal context, particularly from the perspective of secular law, as well as their social and psychosocial, cultural context as well. So each one has developed into an autonomous church in communion with the other churches of the communion, as Norman has said, but each with its own approach to its own context. So And so we have this concept of autonomy for each of the provinces. The highest legislature for each of the provinces is the local general synod, or the body that's perhaps by a different name, but it's the equivalent. And so we have a different way of connecting with each other, which I'll speak about in a little bit later.
Well, you've spoken about the range and the differences of approaches. I think it's right to say in many ways the Church of England is an outlier in that of the 42 provinces, there are certain unusual features that apply to the Church of England. Could you, Norman, explore that a little bit for us and talk about the nature of establishment, which is unique to the Church of England and not shared by other churches of the Anglican Communion?
Well, yeah, absolutely. Conceptually, of course, there is very little difference between the Church of England and all other churches in the Anglican Communion. They're all established, founded as a result of some sort of lawmaking act. The Church of England, like all others, has a system of government. It has institutions to which the law gives powers, upon which the law imposes limitations, about which the law explains relationships institutionally. It has ministry, it has property, it has ecumenical relations. There are so many aspects of the life of the Church of England legally, which are mirrored in the laws of all churches around the Communion. So we mustn't overdo the uniqueness of the Church of England. And as a Welshman, of course, I would say that. But in terms of the legal uniqueness of the Church of England, yes, there are, needless to say. I mean, the Church of England from the 1530s has been a church established by law. So this doctrine of establishment is unique. Though again, throughout the Communion, in the West Indies, for example, as Alan said, in Ireland, in Wales, and in other churches around the Communion, there have been elements of establishment, and in recent decades, lots of disestablishment legislation. But the Church of England is established by law. That is a product of the 1530s, resulting from the legal termination of the authority of the papacy in England and the beginning of the establishment, the setting up, as a result of civil legal action, an institutional church. And what the Tractarians, in fact, in the 19th century called an Act of Parliament church, a church institutionally set up by law created by Parliament, with the royal supremacy. The monarch is the supreme governor of the Church of England. That is a feature of establishment not shared in other Anglican churches. The monarch is involved by law, an old statute of 1533, the Appointment of Bishops Act. The monarch is involved in the appointment of bishops. It is said the monarch appoints them. Technically, of course, the monarch nominates candidates for the office of diocesan bishop, and they are elected by the Cathedral College of Canons. In terms of legislation, another feature is, well, General Synod is the legislator, the Parliament of the Church of England. It has a power to create legislation in the form of measures. This power originally was given to the Church Assembly of the Church of England, but in 1969, the Church Assembly passed a measure reconstituting itself as a General Synod and acquiring the power to make measures. And these measures must be approved by Parliament. They are subject to royal assent. And when royal assent is given, they have the status of Acts of Parliament, the same force and effect as Acts of Parliament, which is a remarkable thing, purely unique in the Communion. General Synod also has the power to make measures and another, to make canons, sorry. And a feature of canons is that they do not need parliamentary approval, but they do require royal assent, and they cannot be inconsistent with or repugnant to, that's the word in the law, repugnant to the Acts of Parliament, the common law, and the royal prerogative. That's at the high level. At the lower level, in terms of establishment, again, features arguably unique to England, though not entirely. Anyone resident in a parish of the Church of England has certain legal rights, for example, to have their marriage solemnized in the parish church. That's recognized at common law too, and they have a right to be buried in the parish churchyard. That likewise is recognized at common law. But then other Anglican churches confer rights to marriage, to the sacraments, and so on. So there's nothing fundamentally unique, but in England, these rights are legally enforceable and recognized under the law of the state. And a good way to determine the established nature of the Church of England, ironically, is to look at the Welsh Church Act 1914, because that act, its enforcement was postponed to 1920, but that act disestablished the Church of England in Wales. And the marks of the former establishment are listed in that statute, and they tell us effectively what establishment and disestablishment doesn't look like. So, in a nutshell, yes, there are certain features unique legally in terms of detail to the Church of England on the basis of establishment, but conceptually, in terms of principle, these features are also shared by other Anglican churches around the world. So you have to have a balanced view of the uniqueness of the Church of England.
Thank you very much. So there we have it, the 42 provinces, one of which is interwoven with the state where it operates. The others are largely unincorporated associations functioning freely within their own states or regions in this autonomous, self-governing manner. But there are certain umbrella institutions which apply across the board to all Anglican churches. And that's where I want to move on to and invite comments from both Alan and Vicentia, looking at what are often called the instruments of communion. 4 or arguably 5, we might come to that. But Alan, can you take the conversation forward? Looking at these overarching organizations which touch upon each province of the Church of England and to consider these instruments of communion.
Well, thank you, Mark. To consider the 4 official ones, noting that there is a 5th unofficial one, we'll start with the oldest one, which is the Archbishop of Canterbury, established in 597. Although in a real sense, not really an instrument of communion until a little bit later than that. The next one was the Lambeth Conference, which first met in 1867 at the behest of initially the Canadian and I believe Australian bishops, who felt that it would be a good thing to get all the bishops together from around the world to discuss the what was then the Colenso affair in South Africa. A little bit later on, in 1968, there was a proposal for a new group called the Anglican Consultative Council, which includes members from each of the provinces on a schedule. Some get 2, some get 3, and then finally the primates meeting, which was established initially in 1976, and I believe it first met in 1977. And that's a gathering of the various primates from around the communion. You'll notice that only one of them, and that is the Anglican Consultative Council, includes people who are not bishops. All the rest only include bishops. They don't have formal authority over the provinces. Again, the question of provincial autonomy comes in, but they are opportunities for us to come together. Norman Doe has suggested the metaphor of centrifugal forces, that is, things that might tend to divide us or draw us apart from each other, and the instruments are centripetal forces, things that draw us together toward the center. And so I'll let him wax more eloquent on that. I would suggest perhaps a slightly different metaphor, looking at Bishop Vicentia's background, and that is the metaphor of a brick wall. I see Bishop Vicentia does have a brick wall right behind her.
Yes.
And you know, the feature of the brick wall is we speak about the bricks. And if you think about the communion as a kind of brick wall, then I want to suggest that the instruments of communion are the mortar between the bricks. Without the mortar, you don't have a wall, you've got a pile of bricks. But the mortar is not what we speak about when we speak about the wall. It's the bricks themselves. And so I maybe suggest that as a potential metaphor. And just a brief story, Archbishop Michael Piers, who was the primate in Canada a number of years ago, told this story about himself. He had a conversation once with Archbishop Desmond Tutu in South Africa, and told Archbishop Tutu how much he really appreciated and loved to quote a line that Archbishop Tutu had spoken about having to do with the nature and strength of Anglicanism. And it was that we meet. 2 words, we meet, we get together. And you could say that the instruments of communion are forums, particular forums for us to meet at a global level. When Archbishop Piers told the story, he said that Archbishop Tutu replied, "Well, I never said that actually, but I wish I had." And so the communion, I think, is this, the instruments of communion are opportunities for us to meet and worship together and enjoy fellowship and discuss the matters of the day, whatever those might be. Certainly in the sense of the Anglican Consultative Council to set up networks for ongoing work between and among provinces and so on. So in a nutshell, that's what the instruments are.
And the one thing noticeable by what you haven't said is the absence of any lawmaking powers within any of those 4 named instruments. But you have said that in terms of participation, they are dominated by bishops. And this seems the right time to bring in Bishop Vicentia to tell us the inside track, to spill the beans on what actually goes on at the Lambeth Conference.
As my predecessor, Desmond Tutu, said, we just meet. There's not much that we do except meet and talk.
I once described the Lambeth Conference as the most expensive Bible study ever staged.
Remember, that's one of our legal, 3-legged stool, the scripture. So it has to be expensive for us to discuss that. As Alan had said, that the first Lambeth Conference was called in 1867, and it's very interesting that 2 of the provinces that birthed Lambeth Conference are in this call, which is Southern Africa and Canada. Canada called it because of what Bishop Collins of Natal was doing that unsettled many bishops around the communion. It meets once in 10 years. It doesn't have power to make decisions. And that is why the last Lambeth Conference, we didn't come up with resolutions. We came up with calls where we urged the faithful throughout the communion to engage in that as we build the communion and relations in the Anglican Church of in the Anglican Communion with it. And I think as you look at its development, that it started with very few resolving the issue, and we realized that there's more that the bishops can do when they meet once in 10 years. The last one, we couldn't make it to, in every 10 years because of COVID. And I think that's another thing that's coming to challenge us. With what COVID has taught us, is it necessary to meet once in 10 years, or we can reduce that or extend it? So these things are not statics. I think the context and where we find ourselves continue to probe us on how we can be, I think, a better church and a caring church.
That's very helpful.
Mark, could I ask a question there?
Of course you can.
Vicentia, that's very interesting. I recall, yes, that Lambeth 22 issued calls, and that Lambeth 2008 was all about Indaba, and previously Lambeth Conference issued resolutions, as you say, which were prescriptive in form. They contained norms, they required, they forbade, they permitted. is there any normative dimension to the calls of the Lambeth Conference 2022, or are they empty of normativity? Do they not contain any expectations, any requirements, any permissions? Are they simply void, blank, normatively? Call.
I wouldn't say that they are blank, because the resolutions were made when the body that made resolutions didn't have power to do that. So they were not binding. So that's, I think, something about the legality of what we do. The calls, I think, they're inviting and encouraging. So you're given a statement, you're given a topic that we hope that as we discuss, we find things that brings us together as the communion, and not what, pulls us apart from each other. And these calls will go on, I think, for another year. So for the rest of this 5 years leading to the next Lambeth conference, as people say, will there be next? We don't know what we will be doing in that space. So those are the challenging things, that every Lambeth creates something that we hope can be sustainable. But in most places, it's not, because of the powers that it doesn't have.
Thank you.
I think
Perhaps I might suggest that I believe it was the 1878 Lambeth Conference also didn't issue any resolutions, but rather a pastoral letter to the communion. I think the calls are kind of, if you will, compelling invitations to act without the power to compel anybody to do anything. But nevertheless, the bishops severally have authority within their dioceses and provinces, depending on the nature of that authority. And so certainly when they agreed to those calls, or even for that matter, agreed to resolutions, they can bring them back to be brought into the law of or the action of the province.
Yeah. And I know of provinces that have taken the calls and put them in their general synod, on their provincial synod, to be adopted as a working document or another way of bringing together. So that's the only place where there's authority for the bishop to kind of insist. But coming from Lambeth, it again, as Domin says, it might be a suggestion, or if you want, you can do it, but we won't hold you responsible if you don't.
I'll return to Norman in a moment to look at what central authority there may be within the Anglican Communion. But Alan, before I do, for those who may not be fully familiar, where is the norm for the usual canon and constitutional lawmaking power within the elements of the Anglican Communion? Where does one traditionally find lawmaking on a local or provincial level?
Well, one finds lawmaking in a couple of different places, and it depends a little bit on the nature of the individual province. As I said earlier, the highest legislature for any given province is the General Synod, or the equivalent body, which might be by a different name. The governing body in Church of Wales, the provincial synod, I believe, is the correct term in the church in South Africa, General Convention in the US, and so on. But we'll use the word General Synod with a small g and small s as a generic term. However, within that, there are different approaches to legislation across the communion. We have some churches which are more centralized, where it's only the General Synod that can legislate, and some, such as my own in Canada, that are decentralized, where there are different levels of jurisdiction. So the General Synod is able to legislate on certain matters, but we also have 4 internal provinces, provincial synods, which also have legislative authority within certain matters. And we also have 30 diocesan synods, which also have legislative authority. So we have, diocesan, provincial, and general synod canons, a much more sort of decentralized version, 35 legislatures in my church. And so, but with that sort of variation at play, each church has its own constitutional construct, whether centralized or decentralized, and each legislature, again, whether centralized or decentralized, has a constitution and canons which affect its own life.
So, as we've already said, 42 provinces, each autonomous, each self-governing with its own lawmaking, whether at General Synod or at a more dispersed level. A lot of people search for analogies with Anglicanism, looking at the Roman Catholic Church and looking for an Anglican Pope with a direct hierarchical power over the global church, which he heads. Now, Norman, can you help us with that analogy? Is there any form of global authority or jurisdiction? Is there any form of central enforcement with these 42 autonomous Anglican provinces?
Well, I suppose, first of all, in order to set out your criteria, you have to have some sort of basic understanding of what a papal system looks like. Far be it from me to suggest anything about the constitutional organization of the Roman Catholic Church, for example. Cristiana Cianito, Professor Cianito, who is here. It's lovely to see you, Cristiana, in Milano, is far more qualified than I. But the Roman Catholic system under the Code of Canon Law 1983, which is the code for the Latin Church, the Western Church, the Eastern Catholic churches have their own code of 1990. Under the Latin code, yeah, it's a hierarchical organization. Full supreme authority vests in the Pope, the Pontiff, which is exercised by the Pontiff either unilaterally or in partnership with the College of Bishops at the universal level. So the Pope has universal authority. That means under the Canon Law Code that the Pope is supreme legislator, can legislate, create law that is applicable to and binding upon all the faithful in the Latin Church. The Pope is an administrator, the Pope is a judge, and the code forbids anyone to challenge decisions of the Pope. So there is that central authority, legislative, executive, and judicial, and then the Code of Canon Law provides a hierarchy of equivalent powers beneath all the way down to the diocese, where the bishop, like the Pope, in a diocese is a legislator, executor, and judge. There's a fusion, if you like, of powers in the office of diocesan bishop, mirroring that of the Supreme Pontiff. So the Latin Church, yes, central authority, Code of Canon Law binding everyone, administered hierarchically in a set of courts, inferior legislators, and all the rest of it, and the power of governance, the munus gubernandi in the Catholic Latin Church, vests in the clergy. The clergy possess the power of governance. The laity does not possess the power of governance. The laity may participate in the exercise of the power of government, but does not possess it. It is centralized to the clergy, so to speak. So if you say they're the marks of a papal polity, then do they apply in Anglicanism? Well, evidently not. But there are equivalents. We've heard about the instruments of communion. The Archbishop of Canterbury, obviously, has not got coercive power over the communion in that way. Cannot legislate, cannot administer, cannot judge. Though there was talk after the First Lambeth Conference of setting up an Anglican International Tribunal. The Lambeth Conference, it has no coercive authority. Its authority is moral, if you like, and its resolutions, prescriptive in form, they're not binding, as Vicentia said, but they are capable of becoming binding because there has been a practice in the communion of provinces, churches, institutional churches adopting Lambeth Conference resolutions and incorporating them into their law and therefore making them binding within the province. So the shock waves, if you like, sent from the center, the Lambeth Conference, can acquire a legal force if incorporated in the law of institutional churches. Next little point, a church, therefore, in Anglicanism, can surrender its autonomy to the instruments of communion. And that is a possibility. And there are examples, particularly in the African churches, of laws which provide, especially in liturgical and doctrinal matters, that if there is a dispute in the local church, the provincial church, the matter may or must be referred to an instrument of communion, and that instrument of communion is empowered by the law of the province either to determine or to give advice on that doctrinal or liturgical dispute. So the laws of churches can confer an authority on these instruments of communion, and in practice they do around the communion. The Anglican Consultative Council is a really interesting one. I mean, the Lambeth Conference, remarkably, has not got a written constitution. It's all unwritten, informal, and so on. But the Anglican Consultative Council has a written constitution. It has charitable status in English law, and it exercises a coercive power. Because, of course, the schedule appended to the Constitution contains a list of those Anglican churches which are represented on the ACC. And it is within the competence of that instrument of communion to get rid of churches on that list or to suspend their membership. So the picture is somewhat more complicated than at first sight. There are examples of the use of a centralized power, or the use of a moral power from the center which gets converted at the level of the province into a legal norm. And finally, the covenant, the Anglican Communion covenant, ratified by the ACC in 2009. That was subscribed to by 10 churches throughout the world. Church of England, somewhat astonishingly, sent it round to the diocese. General Synod sent it to the diocese, and it was knocked down. So the Church of England did not subscribe to it. But that, you see, spells out, the covenant spelled out the Anglican position of non-centralization. The maxim at the root of that covenant was the communion guides, but each church decides. Coercive power is at the level of each church, moral authority at the level of the instruments of communion. And in fact, Section 4 of the covenant never gave to the instruments of communion any coercive power. It only gave power to the individual churches to reconfigure, if they wished, their relationships with other individual churches in the communion if centralized moral advice from the instruments had not been complied with. So that never was a centralized, in terms of assumption, in terms of aim. The covenant never did envisage or put into prescriptive terms the idea of a centralized organ in Anglicanism. So, complex question, pros and cons.
A really helpful example of subsidiarity of coercive power and moral authority. But Alan very teasingly mentioned earlier on that there may be in the ether a fifth instrument of unity, an unofficial one. And let me lift the veil on that teasing secret, because the fifth instrument has been said by the primates themselves to be the principles of canon law common to the churches of the Anglican Communion. And I'd like you, please, Bishop Vicentia, to tell us a little bit about the Principles Project and how we have now ended up with a revised version of the Principles, why the project started, and what it has achieved. So to you, Vicentia.
Yeah, I think the initial stage or the foundation of the Principles was in year 2001, the primates meeting in the US, where we traced the beginnings of the Principles. And in a meeting again of the primates in 2002 in Canterbury, they recognized that all of our autonomous provinces have a law that is common to all churches, but there's no kind of one place where you find it. There's nothing that helps us to really trace it through. And that's when I think Norman, after presenting a very provoking and interesting paper in that space, that he started heading the process of collecting all these laws that are common to us at the Anglican Church. So the first edition was out. I think it was it 2002 or later than that? Yeah, Norman, is it 2002?
2008, the first 2008,
yeah.
the first iteration was published. Yeah,
it was
so
launched at the Lambeth Conference, which took place in 2008.
Yeah, so that was the first principle, but it didn't stop there, because I think after it was published, there was more engagement with the churches, and more was, realized and really worked on. And in 2021, Norman approached provinces. I happened to be part of the province of Southern Africa that participated in that. As we look at this document and look at the laws that govern us in our churches, and what has changed, because in whatever context we find ourselves, civil law does dictate some of the things, how we do it, and are we still in line? And that's what birthed the second edition that was launched in 2022 at Lambeth. So it looks like there's a system of revising and working. So I sense there's a third edition coming as we engage with the law. So they are available, this new edition and the old one, online. Mark, I'm sure, or Dan can give us a link somewhere in the chat, so that people who want to see what is it that we have. And we realized as we're working on it that we don't agree on the same things, but in fraction, not much difference. So we had to look at what is it that is common. Let's not look at what is it that we don't agree with. What is it that anchors whatever we build on? So that's the beauty of this project that I participated in, and that continues to evolve and inform richly the ministry that we do.
And perhaps, Norman, you can share some of the practical de facto uses that have been made of the principles.
Yes, well, I think that actually you very nicely, Mark, displayed the first edition, and there's the second edition. You have it there, wonderful. And the beautifully confected preface of the second edition, as it were, sets out the uses to which this document has been put within Anglicanism, that is. And first of all, the obvious one, academic uses. In those few places around the world, institutions which study Anglican Canon Law, such as at Cardiff University, the document has been fed into those studies whenever there is a comparative element, an inter-Anglican element, that is, to a particular topic. We look at the principles and use them to understand the collective approach of Anglicanism to a particular topic. Second, practical uses. Churches around the world have been invoking, so I understand, I get emails about this, using the principles when they are embarking on some sort of legislative reform or the creation of a new instrument. For example, the Diocesan Manual of Namibia quotes the principles extensively as the foundations for clusters of rules contained in that manual. Third practical example is cases within the church courts. The Wangaratta Blessing Service case, for example, in Australia, in the Anglican Church in Australia, heard by the Appellate Tribunal in 2020, invoked the principles as a persuasive authority. Of course, the principles are not laws. The principles are principles of law. They are induced from the similarities that exist between the laws of these churches. You stare at the laws, you see what they have in common and how they differ. From the similarities, you induce a principle and articulate it as a principle of canon. They're not binding, they don't have force, and nobody in the communion at global level has competence to convert them into a globally binding entity. They are principles of law, though therefore necessarily persuasive, not binding. However, next to the point, the civil courts, strangely, and this was never intended, likewise have invoked these principles. There was a case in the Court of Appeal of British Columbia in 2010, Bentley and the Diocese of New Westminster, the Anglican Synod of that diocese, in a property dispute between Anglicans, again appealed to these principles to help understand the norms of the church involved better. And finally, I too I'm using them currently. The Archbishop of Wales has asked me to review the faculty system of the Church in Wales, and I'm finding that the faculty system is full of gaps. It's full of terms that are not defined, and so I'm turning to the principles as foundational ideas to try and explore and elucidate and improve the faculty law of the Church in Wales. So they are some of the 5 basic ways in which these principles within Anglicanism are being used as a matter of fact. So they're not just on a shelf or on Mark's lovely desk there.
But also, I think it's worth mentioning that beyond Anglicanism, they have a usage. As many on this call will be aware, there's been an ongoing bilateral colloquium between Anglican and Catholic canon lawyers. And one of the Catholic complaints a long time ago was that whereas they had a universal code, for we Anglicans, our law was dispersed amongst all the various different provinces. And what the principles have given is an ecclesial density to our laws, which has improved the nature of that dialogue and the comparisons which are made within it. Because as one distinguished canonist had said, that ecclesiastical law, canon law, is applied ecclesiology. It is a way in which we self-identify as a church and as a communion. I don't know, Alan, whether there's more you want to say about the ecumenical use to which these principles have been put.
Well, yes, I think, first of all, I'd just like to say that Bishop Vicentia was far too modest in not drawing attention to the very fine essay that she has in the principles, revised principles document. So since she won't do it, I will. And just to say too that I think the academic study of canon law internal to our province was very helpful. It helped along by this the study of the principles, and so it has both internal and external areas of interest. But I think Mark, you've touched on the way in which this gives us a kind of I think your phrase was ecclesial density to our laws. As we look at applied ecclesiology across the Anglican Communion, and so that helps us in speaking with other churches, non-Anglican, non-Roman Catholic churches as well, trying to understand from their canon law or equivalent what their ecclesiology really is, and vice versa. They then have something to touch on. You know, particularly looking at, say, something like a full communion relationship, such as the Porvo communion. The Lutheran churches in that can look at the Anglican Church as a kind of coherent group, noting the differences among the various provinces. Similarly, here in Canada, we now have full communion with the Lutherans on both sides of the existing border, the 49th parallel, as well as the Moravian Church. And so the principles certainly give us something to hang our hat on when we talk about those kinds of relationships. And who knows, the sky's the limit, really, in terms of ecumenical engagement. It'd be interesting to see what might happen at, say, the World Council of Churches, whether the principles might have some traction within that body or similar or some of their sub-bodies.
Thanks to the brevity, discipline, and courtesy of our speakers, we're drawing to a close. with 10 minutes before the top of the hour for other people to reflect, give questions and comment. But please indicate with a hand if you wish to say something. But I'm going to give Norman the final word amongst our three speakers to reflect on the use that can be made of these principles.
Yeah, it's just to take up Alan's point there about the wider ecumenical use of them. Yeah, we've used them with the Colloquium of Anglican Roman Catholic Canon Laws, not just to understand, we pick a topic and we compare Anglican and Roman Catholic approaches to it. But above all, this is the spirit of the Principles Project. We then articulate what we have in common, ecumenically, bilaterally, in the form of shared principles of canon law. And then they get fed into, for example, the work of Archic or Iarcum. So they are actually this idea of the use of principles, which goes back, of course, to the medieval notion of a regula juris, a maxim, where clusters, dense lots of legal rules in the church can be reduced to a statement of a principle. Russell Dewhurst's Porvoo project, the new network with Anglicans and Lutherans in the Porvoo community, as it were, communion. That again is another fruit of these principles, and they are likewise working on the articulation of principles of church law in Anglicanism and the Lutheran traditions. And finally, dead on point on Alan's point, thirdly, the wider ecumenical utility of these principles is this. In 2013, an ecumenical panel met in Rome for 3 years, and in 2016 issued a statement of principles of Christian law, looking at the laws of 10 big mainstream historic church traditions: Catholic, Anglican, Lutheran, Orthodox, Methodist, Baptist, and so on, and articulated what was shared juridically in the form of a statement of principles of Christian law. This went in 2017 to Geneva, to the World Council of Churches, and at the 11th Assembly of the World Council of Churches in Karlsruhe in Germany in 2022, this statement of principles of Christian law was launched at that event. And in fact, a year or two before, for the first time in papal history, Pope Francis announced the importance, the essential nature of canon law, of church law in ecumenical dialogue and understanding. And that same year and since, Ecumenical Patriarch Bartholomew, leader of 250 million Orthodox Christians worldwide, he likewise talked about the essential character of this statement of principles of Christian law. So, Alan, it's already happening. In the wider ecumenical sphere, there's Anglican initiative of principles of canon law, and the idea behind it is beginning to reverberate in all sorts of wider ecumenical contexts, even at the level of the World Council of Churches.
And in the absence of anyone else desperate to raise a hand or to speak, I can give one very small example of where the principles were put to use. I've just returned from Nepal, and one of the recurrent difficulties for Christian churches in Nepal is registering as a legal association. And I'm thrilled to say that the Anglican Association of Nepal last October obtained state recognition, and amongst the papers it submitted in order to obtain registration were the principles of canon law common to the Anglican Communion, as it were demonstrating its authenticity and its legal structure as a means of being accorded state recognition for the purposes of holding land, having bank accounts, and functioning within the state of Nepal. So the fringe benefits, the litany of unexpected consequences seems to be growing by the day. Dan, I see your hand is raised. Do you want to come in?
I do. Thank you all very much. I have a question off the back of the conversation about the Archbishop of Canterbury as an instrument of communion and about the lack of quasi-papal authority there. What's the implication for that, for the fact that the next Archbishop of Canterbury that the Church of England is currently in the process of discerning will be appointed in part by a greater number of representatives of the global communion than has in the past? What are the implications to the role of the Archbishop as an instrument of communion and his or her authority on the basis of greater participation of the communion in selecting them?
Do you want to take that one first, Bishop Vicentia?
I see Norman has raised the hand. He might have the up-to-date information that what I have.
It's just a mistake.
Well, we can have a view from Lesotho first, then we can go to Cardiff.
I think, you know, Dan, one thing that is interesting is now with the extended consultation on the appointment, how will it shape the next Archbishop of Canterbury, who again happens to be the bishop of a diocese in Canterbury. So for me, it's an interesting exercise that, you know, some of us who are canon law students are looking at it with interest in what it will birth. Will it be a good thing, or we will regret this experiment?
Norman.
Well, it'd be a lovely idea if, because of this fairly, it has to be said, fairly minimal input from the wider global communion. It'd be lovely to think that that would somehow enhance the moral authority globally of the Archbishop of Canterbury. But in law, nil is the answer to your question. Absolutely nothing. Unless the laws of churches are changed and surrender or confer upon the Archbishop an enhanced authority. But currently, nothing whatsoever.
Alan, do you want to add anything?
Well, at the risk of gilding the lily, I just say we're back to provincial autonomy, and the Archbishop of Canterbury does have a very specific role or set of roles within the Church of England that are peculiar to the Church of England, but no authority outside. Legally, no authority. Morally, perhaps.
As we know, there's a precedent for looking just outside the Church of England when Rowan Williams, then Archbishop of the Church in Wales, was appointed. So we can't say it's a wholly unprecedented step. And the Anglican Communion for a long while has had a voice within the selection process. But as Dan has said, it's a slightly louder voice. And in terms of the voting on the Crown Nominations Commission, there are now a greater number of votes which are held by the worldwide Anglican Communion. So the process may be slightly changed, but I would agree with Norman. The effect of the process in having a more authoritarian archbishop with an enhanced coercive jurisdiction is nil. Well, again, I'm glancing around to see whether any of our distinguished audience want to come back on any of those points that have been made. We only have a minute or so in hand, so if there is a point, it needs to be succinct and well made. But in the absence of that, I think it's testimony to the authority and the experience and the expertise of these three speakers that no one feels able to add to what they have said in their ex cathedra way. I want to note that the next in the ICLARS series of webinars is on the 9th of April. We move to Nigeria, to Bauchi State University, and the conversation on that occasion will be led by Professor Ahmed Garba and discussing the work of his center in Bauchi State, looking at law and religion within Nigeria, particularly the project in which he is involved in drafting a single syllabus for every law school in Nigeria for the teaching of law and religion, which is a work in progress. And I was privileged to be part of a working group that met in Abuja last year, taking that forward. But my primary task and my primary pleasure is to thank Dan for his skills in running this Zoom, and to thank Norman and Alan and Bishop Vicentia for giving us such a wonderful exposition of the notoriously thorny subject of Anglican canon law. So thank you all very much indeed.